From the PEP Radio Newsroom, this is the Lunch Hour News Blast. LGBTQ Nation is reporting this stuff. The Texas Supreme Court on Friday gave judges in the state a pass if they don't want to marry same-sex couples, unilaterally granting public officials the right to discriminate against queer couples. This is merely part and parcel. This is the end run that the U.S. Supreme Court was waiting for to help Kim Davis nudge her case along, okay? Use that as background information. So, in an end run around equal protection concerns, the High Court amended the Texas Code of Judicial Conduct to read it is not a violation of these canons for a judge to publicly refrain from performing a wedding ceremony based upon a sincerely held religious belief. The change follows years of litigation that inspired a lawsuit by a county judge in Texas asking federal courts to declare that Texas law somehow supersedes the U.S. Constitution and does not and cannot punish them for their practice of officiating opposite sex but not same-sex marriages in the state. Again, this is Texas we're talking about. Jack County Judge Brian Umphris, who sued in 2020 because he only wanted to perform weddings for opposite-sex couples, well, he argued that his conduct would run afoul of the Texas State Commission on Judicial Conduct, which it normally would have, except this is Texas we're talking about. Despite protections he believed he enjoyed consistent with his religious freedom rights under the First and 14th Amendments, Houston Public Media reports. I thought your religion stated something about thou shalt not kill. How many people have you sentenced to death, Judge Umphris? How many did you pass along to that Texas Supreme Court, huh? Lord knows y'all down there receive far more people seeking the death penalty. I'm talking about your local district's attorney. In response, the U.S. Court of Appeals for the Fifth Circuit put the lower federal court proceedings on hold and asked the Texas Supreme Court to answer the following question. Does Canon 4A1 of the Texas Code of Judicial Conduct prohibit judges from publicly refusing, for moral or religious reasons, to perform same-sex weddings while continuing to perform opposite-sex weddings? Because you see, that part of the code, well, that requires judges to refrain from behavior that would cast reasonable doubt on the judge's capacity to act impartially as a judge. The High Court's answer? Well, that came with the amended Code of Conduct, bypassing complete public argument and dissent. Judge Umphriss's fear of sanction for his discriminatory conduct was based on the case of McLennan County Justice of the Peace Diane Hensley in Waco, who spent years in court arguing she had a right to refuse to marry gay couples. She sounds, again, like Kim Davis. Keep that in mind. Hensley replied to requests from gay couples with a statement that read, "I'm sorry, but Judge Hensley has a sincerely held religious belief as a Christian and, well, will not be able to perform any same-sex weddings. You're going to have to pretend that separate but equal from Plessy v. Ferguson is still the law of the land back in the 1890s, and you're going to have to roll on off to another county and get married there." Well, that conduct earned a public warning from the Judicial Conduct Commission, which said Hensley was violating a requirement that justices of the peace be impartial, which they're not, even in extrajudicial duties like officiating weddings. Folks in Texas, come to Pennsylvania. Come to Pennsylvania, come to New York, Vermont, or Maine, or Massachusetts, where you can get married and you don't have to worry about the crap down in Texas anymore. Well, her refusal to treat LGBTQ people equally, that casts doubt on her capacity to act impartially to persons appearing before her as a judge due to the person's sexual orientation, the commission wrote. As it should. As it should. Hensley claimed that no one's rights were denied since a same-sex couple could have found another judge to marry them. Plessy v. Ferguson! Despite the fact that she was the only justice of the peace performing marriages in Waco at the time. Hensley filed a lawsuit against the commission with help from First Liberty Institute, a Waco Christian group out in Oklahoma. Oh, I'm sorry, they're a Texas-based anti-LGBTQ plus legal organization arguing for protections under the Texas Religious Freedom Restoration Act. The commission eventually dismissed its sanction a few months after the Texas Supreme Court allowed Hensley's case to proceed. That decision from the Texas High Court earned Hensley a supportive concurring opinion from the bigoted Chief Justice, who publicly supported the Waco judge before his appointment. Judge Hensley treated them respectfully. Chief Justice Jimmy Black, whatever his name is, wrote of the couples she refused to marry. They got married nearby. Oh, sure. Yeah, where? New Mexico? Arizona? Some other state? Huh? So that's how you treat Texans, is it? They went about their lives. Judge Hensley went back to work. Sure, marrying opposite-sex couples. Her Christian conscience is clean as her soul. Right. Her knees bent duly to her God, whatever that means. Sounds like a win-win. Well, Jason Mazzone, a law professor at the University of Illinois at Urbana-Champaign, who's familiar with both cases, said the Texas Supreme Court's code of conduct is bullshit. And its workaround still leaves open the possibility for a gay couple withstanding to challenge a judge's decision not to bury them on constitutional equal protection grounds. You see, the 14th Amendment applies to LGBTQ plus people too. One of the claims that I think will be made in response to litigation that is likely is that, well, there are other people who can perform the wedding ceremony, so you can't insist that a particular judge do it, Mazzoni said. That, of course, is not how equal protection works, and we learned that back in 1896 with Plessy v. Ferguson, which was updated thanks to our friend Robert Jackson, U.S. Supreme Court Justice from New York, in Brown v. Board of Education. That's how we expect government officials to operate. And that is News Blast for this hour. If you are in the Meadville area, be sure to stop by your local area Walmart and visit the Special Olympics table at the grocery entrance. All proceeds raised go to the Meadville Special Olympics. PEP Radio is available on the Live 365 app, the PEP Radio page at paequality.com, Roku, and Alexa. And frankly, I don't want to read another story from Texas, but if I have to, I will. Just to make sure you're staying updated on the news, and just so that you're aware of the threats that are eventually going to land before the U.S. Supreme Court, side by side with Kim Davis. Once again, up at next, we have the Meadville area weather forecast right here on PEP Radio.